The legislature has always encouraged such charitable trusts by giving them exemptions from paying income tax since as early as 1886. Now, the Modern Income Tax Act also provides for similar benefits. However, it has been a decades-long struggle for the tax department to check misuse of exemptions. Now, this debate climaxed in the Supreme Court, with the court hearing 110 applications by the tax department against various High Court orders. The RT department had challenged various High Court orders that held that charities can undertake business and commercial activities and still go ahead and claim tax exemption. Now, under the Modern IT Act, Section 215 defines what qualifies as a charitable purpose. Trusts engaged in relief for poor, education, medical relief and general public utilities qualify as charitable. Now, I'd lay emphasis on GPUs or general public utilities. The question before the Supreme Court was to decide on what are the conditions under which these general public utilities or GPUs can in fact be exempt. But what are these GPUs? Well, examples would be municipal corporations, state cricket associations, regulatory bodies like the ICAI, which is the governing body for chartered accountants, trade associations, as well as government not-for-profit bodies like the National Internet Exchange can also be GPUs. Now, Section 215 also declares that a charity is not a GPU if it does any commercial or business activity or charges any fees or levies. It further clarifies that commercial activities can be allowed if done to advance the objective of that charity. It also clarifies that revenue from these commercial operations should not exceed 20%. So what is the Supreme Court judgment? Well, in broad terms, Supreme Court has clarified that carrying out commercial activities or levying fees will bar the charitable trust from claiming exemptions. Supreme Court has held that revenue or fees beyond nominal levels required to sustain will invite the scrutiny of the tax department. So what will be the implications? Well, for statutory corporations like government bodies performing functions like water supply, housing, sewage treatment, the Supreme Court has held that they perform a public function and therefore can claim this exemption. What about statutory regulators like the ICAI, the governing body for chartered accountants? Here, the Supreme Court has held that only activities like prescribing standards, setting curriculum and certification will qualify. Any further activities like coaching classes or registration fees would be commercial and therefore not eligible for exemption. For trade bodies, Supreme Court clarifies that commercial activities beyond advocacy may be impermissible. Similarly, for non-statutory bodies like the National Internet Exchange of India, they can claim exemption for performing public functions. The state cricket associations, however, could be in a spot of bother. Supreme Court held that they receive huge proceeds from the sale of media rights from BCCI. Supreme Court also recorded that they own stadiums. They received entry fees from fans, sponsorships, as well as ad revenue. In fact, the Supreme Court has asked the tax department to review their accounts for checking for eligibility. Now, it would be interesting to see if this judgment has any bearing on the BCCI, which is also seeking similar tax exemptions. But many experts are wondering if this judgment has raised more questions than answers, and if the Supreme Court judgment could lead to differences in interpretation and possibly even greater litigation.